Thank you, and thanks to everyone for inviting me here today. I managed to make it, notwithstanding the weather and the flight cancellation last night. So I wanted to talk about drones, which is what people are now calling these technologies. From my point of view, they're model aircraft. Obviously, I don't need to tell people here that we are referring to. Sorry, that better? Good, thanks. So when I talk about drones, I obviously am not referring to the military hardware that's being used overseas for arguably controversial purposes, but instead small flying robots, such as the one pictured here and the ones that you can see out there in the demonstrations. I actually started building and flying model airplanes, what we now call drones, 20 years ago. This is my very first model, and it actually has a connection to agriculture. I was living in the Midwest at the time, and this plane met its demise in a canola field. And I couldn't find it. It was eventually found by a thresher. The farmer called me up, and I did get it back, but not after some effort. So I go back sort of way back with model aircraft and agriculture. And my revenge is this. I now have a camera on board, and I can cheat at the corn mazes. So this is a corn maze in New Jersey where I live. And with permission of the farmers, I went up and did a recreational flight, which I later used to get out of the maze. But apart from fun, obviously drones or unmanned aircraft systems have a wide variety of really useful applications, including wildlife monitoring, environmental anti-poaching activities. I think people have already spoken about the infrastructure inspection application. I've got another client, apart from Raphael, this is Texas EquiSearch, Gene Robinson. They use that unmanned aircraft system, that model aircraft, to look for missing children on a volunteer humanitarian basis, and they've actually done that successfully. The plane has actually spotted the remains of 11 bodies, and in one other case has actually brought home kids alive who otherwise would have been in big trouble. And of course, we're here because of precision agriculture, both the sensor side and aerial application. Yeah, thank you. The technology is actually not all that new. In Japan, farmers have been using remote-controlled helicopters, such as the one here, for 20 years in partnership with the Japanese government, which asked one of the Japanese corporations to develop this system to assist farmers to better and more efficiently manage their crops and apply pesticide in an environmentally friendly manner. And so here you see the application of the pesticide. I'm not going to name brands because this company's not here at this show. The projected economic impact, I don't know if this has been mentioned before, but this is huge stuff, and agriculture really is going to be the top application market for the technology. AUVSI, whose chapter president, I believe, is here. They have a booth. Please go see them and talk to them. The Association of Unmanned Systems, Vehicle Systems International, sort of the leading trade organization on behalf of these technologies, not just in aviation, but also ground and water, put out this report anticipating $82 billion in economic growth for the country over the next short period. And agriculture is definitely a big part of that. I took out of the report, this is the table of agricultural spending, and it's broken down by state, and it includes Illinois, and if you just go across, you'll see it's tens of millions of dollars, even in the early stage. We're talking about a lot of economic activity and also a lot of jobs. This is the Illinois graph specifically. And you can see that there's employment anticipated to grow over the course of the next 10 years and hundreds of millions of dollars in even just the state taxes in terms of revenue to the state as these systems are used and deployed in agricultural and other applications. You've probably heard about my case for Raphael Perker. Raphael, who actually is here, and if you look carefully you might find him, I'm not going to point him out, but he is here attending because he cares about agricultural applications of the systems that he designs. So he is known for taking spectacular videos around the world, cities and landscapes, glaciers in Europe, in the United States. And a couple years ago, he was flying at the University of Virginia in connection with a possible video shoot for commercial purposes to put together a video for the medical center with permission of the university. The FAA saw the video. It wasn't actually made into a commercial, but they saw the video and they took exception. They said, well, this is commercial use because you're being paid, and it's an unmanned aircraft system, and that's not allowed, and we're going to fine you $10,000 because we feel that you flew too close to people and buildings and you endangered them. So they invoke the aviation regulation concerning reckless operation of an aircraft, which typically pertains to people who land on highways and run out of fuel and do dangerous things with passenger aircraft. They tried to apply that to unmanned aircraft systems to model aircraft, even though for decades they'd never regulated or enforced any rules with respect to model aircraft. That, by the way, is a 5-pound styrofoam flying wing with a GoPro camera. I don't think it would hurt anyone, even if it hit you. So we defended the case, and we look back at what the law actually is. And as it turns out, the FAA has no regulations specifically concerning model aircraft or unmanned aircraft systems or drones or whatever you want to call them. Unmanned flying devices are not regulated, with some exceptions like kites and rockets. But what they do have is this 1981 advisory circular asking for voluntary compliance with certain safety guidelines, like not flying above 400 feet, which is something that I think a lot of people talk about. Where does that 400 feet come from? It comes from this, the 1981 voluntary advisory circular saying, please limit yourself to that. Don't fly near airports. Be sensitive to noise-sensitive areas, and otherwise just setting out general guidelines. And that was a situation for decades with respect to what was the FAA's position as to model aircraft. They were not enforcing safety regulations. They did not pursue people who caused injury to others. Those were personal injury state tort claims. So there have been injuries over the years. There have even been a few deaths in the United States as a result of model aircraft operations. And those, just like lawnmower accidents, tend to be resolved in state court under tort laws, personal injury law. In 2007, though, the world changed a little bit from the FAA's point of view, and it issued a policy statement saying, for the first time ever, that the business use of model aircraft was not allowed, that the guidance back in 1981 was actually just for recreational or hobby use, even though it doesn't say that, and even though they never made that distinction, and even though Hollywood has been using model aircraft for decades, including in that film The Aviator with Leonardo DiCaprio. I don't know if you remember that one. That was a $100 million grossing box office hit. They used model aircraft for the special effects to show the models flying over LA Harbor. After issuing this policy saying you can't fly for money or for a business purpose, whatever that means, they then proceeded to send out cease and desist letters and to tell the media that business use was prohibited. So you get all sorts of articles like this: it's illegal, you can't do it, and actual letters to people saying exactly the same thing. And again, we challenged this on the basis that it's a policy statement, not a regulation, and the administrative law judge at the NTSB agreed with us and dismissed the case, finding that there was no regulation at that point in time, when Rafael flew in 2011 at least, concerning the operation of a model aircraft. And so in his decision, he dismissed the case. The FAA has appealed, so the precedential value of that decision is sort of suspended. We have to wait until the appeal is heard. We might get a decision in the next couple of months. People always ask me, what's going on? When's the decision coming? I don't know, but it could be in the next month or two. The NTSB needs a chairman after the resignation of the past chairwoman. But I actually want to talk about something a little bit different from just the aviation regulations, because I think there's this large underlying issue that no one really appreciates, and that's who owns and controls the airspace above private property. And it's really something that the country has not had to deal with for decades and decades. If you go all the way back to the start of the country, even to England back in the old days, you have a common law, which is basically just another way of saying traditional law doctrine, called ad coelum, which basically says that a property owner owns not only the grass, the land on the surface, but also the mineral rights underneath the surface. So if you happen to strike oil, guess what? You're going to be rich. That's your property. And also, most importantly, as to what we're talking about today, that you own the airspace above private property. And so it leads to all sorts of issues like, well, what about aerial trespass? If your neighbor builds a structure that overhangs your property line but doesn't actually touch the ground, you still have a trespass claim. You still have legal rights to get them to take it down or to compensate you for the intrusion into your airspace. There's a big problem, though. In the 1920s, this came along, right? So we had this doctrine that said the airspace is private property, and if you trespass, it's an actionable wrong. You can actually sue somebody for trespassing into your airspace. All of a sudden, we had airplanes, and people wanted to fly across the country, and the economic utility of allowing people to do this is the Wright brothers here, was self-evident. Obviously, we wanted to promote, encourage, and allow aviation, but how could you do that if you're going to trespass with every flight? So there are all sorts of proposals floated. Maybe the doctrine of ad coelum never existed. It never was really to the heavens. That wasn't really satisfying to all the smart legal minds back in the 20s who kind of knew that if you had a doctrine and you applied it for 100 years, you probably couldn't ignore it for the next 100 years. Someone proposed this, maybe airplanes to just fly over streets. I think you all know that's a problem. And impractical. This actually is a picture, ironically, between the White House on the right and the executive office building. It was a demonstration right in Washington, D.C., where you really should not fly a drone today. I'll say that much to you guys. So that was not there really wasn't a practical solution to the problem. The solution that was worked out in 1926 by Congress was to designate the upper airspace and to create a private right of transit through the national airspace, through the navigable airspace. So in other words, you don't have a right to sit up there and occupy it and take possession of it, but as a U.S. citizen, you have the right to transit through it. Even though it's private property, it was basically like an easement type of theory in terms of the law. So all of a sudden, you had permission for people to fly across someone else's land, but only at and above the minimum safe altitude, which is what navigable airspace is defined as. And if you look at this, if you look at the statute, you can see that the navigable airspace is defined as the regulation concerning minimum safe altitude. So let me try to make this a little bit more understandable. Here's a house or another structure, and you've got this concept of the minimum safe altitude is some level above the private property, and everything from that level above is considered navigable airspace. It's safe to fly there, and because it's safe to fly an aircraft there, it is also legal to do that without either causing a trespass claim to be filed against you or to otherwise intrude upon private property rights. And that was sort of where the balance was arrived at in the 20s from Congress in terms of the trespass private property argument versus technology that everyone wanted to use, and we needed to get around this legal challenge. Then we had an interesting case. I don't know how many of you know the Cosby case, 1946 Supreme Court case involving farmers in North Carolina. Their problem was that the U.S. military was this was wartime, the U.S. military was flying planes down to a runway. It was an airport that had been converted for military use, and they were flying, I think, 83 feet above their land, right over a chicken coop, and literally scaring the chickens to death. And the Cosbys actually filed suit against the federal government, claiming this is a Fifth Amendment taking. You are basically taking our airspace, these constant overflights, so low to the ground that is damaging our livestock, is a Fifth Amendment taking and or a trespass. And the case actually went all the way up to the Supreme Court. And in U.S. versus Cosby, 1946, guess what? The Supreme Court said that a landowner must have exclusive control of the immediate reaches of the enveloping atmosphere. And it reiterated that the landowner owns at least as much of the space above the ground as he can occupy or use in connection with the land. Even though they acknowledged at the outset that the airspace is a public highway, there is a limit to what that public highway is, right? And the case before it was 83 feet. And so what they said is, you know, if the Federal Aviation Agency at the time, which was not the FAA, it was the precursor Civil Aeronautics Board, but if that agency said 83 feet is the minimum safe altitude, you can fly across private property because that's navigable airspace, the Supreme Court would have a problem with that regulation because it would pose all of these same property rights, takings issues, trespass issues that were raised and resolved in the 1920s as to where someone can fly an airplane across private property. So when you think about these things flying through backyards or across your land, you kind of think about, well, you know, most of what we're seeing out here at the demonstrations is pretty low altitude stuff. You want a picture of your cornfield or your soybeans, you're really not entering what is defined as navigable airspace, which is the airspace that the statute specifically says the FAA has the authority and jurisdiction to regulate. So there's an argument, and it's one that we raised in the Perker case, but it was not decided, and it's an argument that we raised in the Texas EquiSearch case, which is still pending, which is just an argument. It's not legal advice to anyone here, because I can't offer legal advice to non-clients, but there's an argument that if you're not in navigable airspace, you are not subject to FAA jurisdiction, because the statute specifically says the FAA regulates navigable airspace. You are actually in your own private property. If you put up a windmill, flagpole, a crane, what is the difference? You don't have to call the FAA. What is the difference between putting up that flagpole with a camera on it or a crane versus using something that uses propellers with propulsive forces? You're basically still using the same airspace, you're just using a different kind of device to get there. And so an argument that perhaps there's still a property right that hasn't been resolved in the courts that stems all the way back from the Cosby case. The FAA will completely disagree with that argument. In fact, they've already done so. So this is one of those cease and desist letters that they sent out where they specifically say to Mr. Timmer, who chases tornadoes using RC aircraft and quadcopters, they say in the cease and desist letter, landowners do not have any jurisdiction over the airspace above their property and cannot prohibit or allow aviation operations over their land. It seems to me that statement is in conflict with the decision in Cosby, which says the exact opposite. Here's another statement from, this is the Assistant Chief Counsel for Regulations at the FAA, and this is with respect to what can a local town do in order either to allow or prescribe UAS or drone or RC activities. And from her point of view, local jurisdictions do not have authority to regulate the use of the navigable airspace or the safety of flight operations, and there'd be a preemption question. This completely overlooks the property law argument that needed to be resolved with respect to the Fifth Amendment constitutional takings clause way back in the 1920s. The FAA also talks about it in their so-called myth-busting page, which I have reason to believe was posted as a response to the Perker decision. It went up that same night, just a guess. And they talk about FAA being responsible for everything from the ground up. So if you mow your lawn, you're giving the FAA an extra inch, and if you dig a hole, you're giving them another 3 feet. If the definition of airspace is ground up, then it seems to me they are taking all of it within their jurisdiction, and they're telling you what you can or can't do with it. And there's an interesting question there about whether that matches their statutory mandate and what the constitutional and property rights implications of that reach actually are. I want to talk a little bit about state law, because we've seen a rash of state legislatures come out with new statutes and laws basically to prohibit the use of unmanned aircraft systems. Texas was one of the first that came out there with their bill. Most of them are focused towards law enforcement use, either limiting or requiring warrants, but some of the bills have actually required or prohibited or limited private use of these systems. And there's two edges to the sword, right? So you've got potential limitation on your ability to use such a system under state law. It tends to focus on privacy, surveillance, things like that. And then you've got the opposite, which is that if someone is using a system like this to observe what you're doing and they're intruding on your private property, there may be a statute to protect you. So let me give you the example of the Texas case. This was it's hard to see, it's washed out here, but this was a picture taken by a hobbyist with, I think, a quadcopter who was just flying around in Texas for fun. And he noticed that the stream was discolored. It was a bright red color. And he called in the EPA, or the Texas Department of Environmental Protection. And it turned out that a slaughterhouse was dumping pig's blood straight into the river. And that incident resulted in criminal convictions for the business or the individuals involved. The result of that incident was that the local state representative, Lance Gooden, immediately proposed a bill criminalizing the possession of a drone and a camera. So if you just had the technology in hand, you were committing an offense. That was the original draft of the bill. It would actually criminalize ownership of this kind of surveillance device, which is how it was thought of. There was a lot of lobbying and efforts to kind of mitigate the sort of harsh and potentially First Amendment infringing proposition in that original bill. So as it turned out, now it's really a prohibition on the intent to surveil private property. So if someone is going up there with one of these devices with the intent to monitor agricultural operations, livestock, at least in Texas, there is state law protection. And there's a lot of debate. There are now 15 states, roughly, that have put something like this into place, mostly, as I say, with respect to law enforcement. But also some of them have gotten, I think Wisconsin is the latest, that has a pretty significant restriction on the private use of these systems, particularly when you're taking pictures. So that's something to keep in mind that I think is moving more quickly than the FAA, and may be an area where if you're a concerned user of this equipment or potential user, you might want to see what your state is doing and write to your representatives if you don't think they're doing the right thing, if you think they're inhibiting the technology. For example, Virginia has a moratorium on all state agency use of unmanned aircraft systems through 2015. So if you're a police officer and you want to take a picture of an accident scene, you can't do it. If you're an environmental agency in Virginia, you can't do it. So in my view, that's short-sighted and really inhibiting the use of the beneficial use of the technology, even in non-controversial applications where there isn't a privacy issue at all. And of course, privacy does play into this, and we do have existing laws, existing Supreme Court decisions concerning what are your privacy rights from the air. And if you go back to cases like Florida versus Riley, these are the cases where the cops are flying over the marijuana fields, or even, I think this picture is the crop is being grown in the greenhouse, but the roof is open, you can't see it, so they could actually spot the plants. And they were at 400 or 500 feet, and the decision for the Supreme Court was, is there a right of privacy vis-a-vis Fourth Amendment search and seizure law with respect to aerial photography? And the answer is no, because airplanes fly at that altitude, and people can observe you from that altitude without restriction. There's no privacy right, there's no ability to exclude evidence that's gathered by police officers, even in the absence of a warrant from that altitude. So when we hear news reports about privacy concerns, police use of drones, all that kind of stuff, if they're flying in the same location as a manned aircraft, it doesn't make sense to me, vis-a-vis the existing Supreme Court precedent, that you would say there's a privacy right against drone photography when there isn't one against manned aircraft photography. Now, the interesting question is, what happens when you fly lower than the altitude at which manned aircraft are flying? So at 100 feet, at 50 feet, can the police take a picture from your backyard or from your farmland and use that in evidence without a warrant? Do you have a reasonable expectation of privacy that there wouldn't be a flying device at that altitude? And remember, with respect to Fourth Amendment, reasonable expectation of privacy turns on reasonable expectations. What are the community standards? As these devices proliferate and spread in different industries, people's expectations are going to change. And the Supreme Court might one day say, well, these things are flying everywhere, and so there either is no longer a privacy interest, or it's been mitigated or changed as a result. But we know that once you get up into the navigable airspace, there really isn't that right anymore. And so you could have PETA flying over your land in a manned helicopter and taking the photographs, and there wouldn't be an issue with that. You could have the environmental agency doing that. And if it's manned or unmanned, I don't think it's necessarily going to make a difference. ACLU has weighed in, and they actually are on both sides of this. They see the First Amendment right to gather information using an aerial camera, but they also are concerned about Fourth Amendment search and seizure, the right of privacy. I would say the privacy right is probably of greater concern to them, but there are actually two groups within the ACLU that kind of see it both ways: the right for news organizations to go out and gather information that's newsworthy and relevant to the public, and also the flip side about police use of this kind of technology. Now, everyone is talking about this thing that happened a couple weeks ago, the new agency interpretation. I'm not going to give you an analysis of it. I can't do that. It would be legal advice. But I'll talk generally about what I think the agency is doing or what the agency has tried to do as of a couple weeks ago. I think that as a result of the Perker litigation, and also because of the proliferation of the systems, everyone wants to use it. People are using it for commercial purposes. There's no doubt about that. That the agency is just looking for a legal hook to reinstate that 2007 policy ban on commercial use. So this notice of interpretation of the 2012 statute, I think, is another attempt by the agency to say to everybody, you can't use these systems commercially yet unless we approve them, and there are some limited ways of approving them. although those are quite limited. Everyone talks about the Alaska approval to the pipeline operation. You should know that that's not what it sounds like. The only way to get that kind of approval is to have a DoD certified military surplus UAS. Because that's a restricted category type certification. So you couldn't take any of these multi-rotors or other aircraft that you're seeing today and go to Alaska and get the same kind of authorization, because you would need DoD, Department of Defense, military hardware to get that kind of application. Yes, it's being used for a commercial purpose. They're allowed, it's a contract with, I think, ConocoPhillips or Exxon to use the technology, but it's not what we think of as the commercial use of these devices here, and it's not really going to be what the regulations are bound to be in the future with respect to agricultural operations. It's a one-off thing, and also it was specifically requested by Congress that the FAA allow the Alaska operations, get to work in Alaska with these systems. So that was another impetus for the FAA to allow something to happen there, and it's very limited. It's remote locations. So that's not really a path forward, although the PR spin and the media coverage makes it sound like there's been a commercial approval. It's very, very limited. The other thing we've heard lately is this Section 333 exemption, the Hollywood filmmakers who've submitted an application. The FAA says they're considering that, but those are closed sets, they're defined locations. I don't know if you've read the application, but it talks about a certificated pilot actually operating the drone, so it's not Hollywood photographers just going and using the equipment, it's actually certified pilots. So again, the hurdles even for that kind of approach, if they do get approval, which is a big question mark, seem to be pretty high. And I think it's indicative of what regulations are coming down the pike as they move forward with their schedule to present proposed regulations in November, which is what the schedule now is. I think we're going to see very onerous, burdensome regulations, pilot certificate requirements, airworthiness for the airframe, which is typically a 7-figure proposition for the manufacturer. So you're talking about millions of dollars to get the certification, just like Cessna has to get for the manned aircraft, medical exams, all sorts of regulatory hurdles that one could argue are not appropriate for things that only weigh a few pounds and that you're just flying a few feet above open lands like these in what the Supreme Court might consider to be private airspace. So, and you see they've called out specifically in the notice of a couple weeks ago agricultural operations, because I know they have gotten a lot of questions and they've gone back and forth. I think sometime in the fall, somebody out of the FAA said, oh, a farmer just using these things to look at their own crops, not a problem. They backtracked in January at a conference and they said, no, that we were talking about hobbyists. If you're doing it in connection with farming, that's still going to be viewed as commercial, and it falls under our same agency framework of not being permitted without our permission. And here they've called it out specifically. So if you are determining whether your field needs water for personal enjoyment, that's hobbyist activity. But if you're determining whether or not crops need to be watered as part of a commercial farming operation, that's going to be viewed as commercial activity. And under the rest of this notice, and I won't speak to the validity or legal significance of the notice, but under the FAA's statement, that's not permitted except with the kinds of authorizations that I've been talking about. So if you're going with what the FAA's position is, you have it. As to whether or not it's something that has more legal effect than a policy statement, I'm going to defer questions like that, although I will take questions at the end. One thing I'd encourage you to do, though, to the extent that you have an interest in this technology and you think that this notice or the general approach of the agency is not what you'd like to see as citizens or as people in this industry, this is the most important industry for this technology in terms of the anticipated dollar revenue to the manufacturers, to American jobs. You should comment on this notice of interpretation, and all you need to do is go to regulations.gov. I think this notice is one of the top trending notices out there now, so you'll easily find it, or you can put in FAA. I think you can. There's a lot of news coverage that links to it, so it's not too hard to find, and if you can't find it, then just drop me an email and I'll point you to it. But they are taking comments on this, and I think on the topic generally, through July 25th. So there's a narrow, and I don't know that they're going to look at them or consider them, but certainly the more people who speak up and say this regulatory approach of making this technology that's out of the reach of small businesses, or even large ones without onerous and expensive equipment. I think the government should hear from people who want to use the technology. That's really the function. And really the core argument in the Perker case, it sounds like a technicality, but it isn't. It's the notion that before an agency issues regulations or bans or prohibits a new technology from people who want to use it, that there's a notice and comment rulemaking process that Congress requires the agency to undertake. And they didn't do that in 2007. They issued it as policy. And they said as a matter of policy, commercial use is banned. And from that, they tried to fine Mr. Perker. And they've also shut down Texas EquiSearch. And I think it's a core principle of democracy that before the government takes those kinds of actions and shuts down productive technologies, that they consult with the constituents, with you, with people who want to use the technology in one of the most important industries in the country. So I'd encourage you to put in your comments if you have them. It's regulations.gov. And there's also on there you'll find like a PDF that's tips for submitting comments. You could even just Google this, tips for submitting comments on regulations. The government has its own suggestions about what comments are most effective. And those tend to be ones that are specific. Say something specific about what you want to do and why this regulation or the existing regulatory approach is going to constrain you, as opposed to just, a lot of people want to put out a form letter and then copy and paste and think that there's benefit in numbers, and there may be, but by far, comments that are specific and personalized as to what you want to do are going to be more effective at getting the agency's attention, and that's set out in the tip sheet. So I'm just going to put this oil rig up, my last slide, and to go back to that airspace issue, again, you own land and you strike oil, and there's value there that you didn't anticipate. And by the way, whoever built this rig did it below naval airspace, I presume without contacting the FAA. But don't fly around it. But the point here is that there's now this value in the lower airspace, right? So for all these decades, what was really valuable to the nation in terms of its airspace, which is a shared public commodity, public navigable airway, is the ability to go from point A to point B. So I want to take cargo across the country, or I want to take passengers and charge money for it. And what was important is you had to get up into the minimum safe altitude. By regulation, you had to fly 500 feet and above. I can't fly back to New York at 400 feet. It's a violation. So anyone who wanted to fly, get a pilot certificate, run an airline, had to get up into that navigable airspace. But what's now valuable about the airspace for the first time since the 1920s is that lower altitude, right? The airspace below minimum safe altitude, where you're going to fly these unmanned systems. And so people are now waking up, I think, although slowly, to the idea that this airspace, which the Supreme Court in 1946, I would say more than suggested, really quite clearly said belongs to and is controlled by the landowner, it's part of the property right, is now valuable perhaps in surprising ways. We didn't really envision this kind of technology making it useful. And if you're using the technology in connection with your use of the land, there seems to be an unresolved issue about whether you can take that airspace as sort of a right over use of that airspace, notwithstanding what the FAA says about its own control down to the ground. So that's my presentation. I'm happy to take your questions that don't go to offering legal advice. Yes. And I think there's is there a microphone around just so everyone can hear the questions? And we have about 5 minutes or so.
How can the FAA delineate the safety concerns between something that's recreational and something that's commercial? Is there a difference? Must be a difference.
The question was the delineation between recreational and commercial, and how can the FAA delineate? It's true in the regulatory world across agencies that as soon as you start charging money for something, like a taxi service, you become subject to regulation because there's a public trust issue. Number one, you've got people getting on airplanes, paying money, and they expect to be safe. And if they didn't feel safe, you'd have a loss of confidence in that industry. Number two, there's a philosophy that when you charge money for something, you might be more willing to take risks. Like, yes, I'll fly over that highway because you're offering me money, and as a hobbyist, I wouldn't. I think we've seen over the past few months that really isn't true in this field. People are doing interesting things, perhaps objectionable things as hobbyists, and they're also commercial operators who are acting extraordinarily safely, and yet they're subject to complaints by the agency. So the whole paradigm of commercial recreation, and it doesn't matter if I'm flying out in the middle of nowhere and it weighs 5 pounds or 3 pounds, is a really a public safety issue there if you accept money. I think that's a really interesting open question, and maybe we need to revisit that.
Another question? Let me bring the mic back. So that everyone can hear the question. If it's determined that
Put that slide up, my contact is on.
have jurisdiction of this airspace below 400 feet, do you think we're going to see a patchwork of state and local governments passing restrictive laws?
It's possible, and maybe I'm too optimistic, but what I would like to see is states becoming sort of welcoming to the technology, sort of like the Silicon Valley, Motor City. Why shouldn't states want to attract the development of UAS technology and encourage their use and development, as opposed to just thinking about purported privacy issues and restrictions on the use and warrant requirements and things like that. So I think you could end up with patchwork, and that could be unfortunate, at least at the initial stage, but as the benefits are seen, I think you would have competition among states to attract those industries and to develop the technology, and that would result in laws that are friendlier, I hope.
I think we have another question right over here.
In the context of precision agriculture, has the FAA taken any action against anybody in the space, or are they just talking about that?
I am defending an investigation involving someone using a model aircraft in an agricultural application. I can't say anything more than that. But yes, it appears that they are also targeting or investigating people who are using the technology for agricultural purposes. And by the way, it's a really beneficial use of the technology. It's actually a great idea, and I think very safe, but that's
Okay, we have time for one more, and I saw this hand up before I saw the other one, so we'll go over here with this question, and then away we'll go.
Good afternoon, I really appreciate the presentation. Let's go back to section 333. Jim Williams, earlier this year, May, at the Subsystem Conference and at the PAAS conference, said that the FAA was considering section 333 waivers of virtually every regulation we have for practice support, among other industries, precision agriculture. You talked to the film industry, and currently the chief engineer of the UAV services company in Virginia. We intend to obtain a section 333 waivers for precision agriculture. Can you talk about what's your assessment of how likely the FAA is going to do? Again, if that would allow us to legally fly precision agriculture along for this notional spring 16 small UAS regulations that likely to come out.
It might, and obviously the recent news, including my cases, I think have applied some pressure to the agency in a good way to try to open up some commercial applications, and I hope that works. But I'm a little skeptical. They say they're considering it. The filmmaking application, there was actually a filmmaking exemption filed 2 years ago that was completely ignored. You can look it up. It's ISIS Copter, ISIS Copter. It was published in the Federal Register. They asked for basically the same kind of waiver or exemption to do filmmaking in a safe way, and the agency completely ignored it. Now, I don't know that they can ignore this round, especially when they're going out and promoting it, so maybe there's some optimism there, but I think it's going to be very slow, and there's no set process for applying for that exemption. So you're sort of guessing at what they want, and I expect there'll be several rounds of coming back for more. And do you need a pilot? Where are you flying? What are you doing? How far in advance do you need to notify the FAA? What's the altitude? Do you need to file a NOTAM? All these kinds of things that will resemble aviation today from the man point of view. You've got a pilot in command, I think will probably be applied to those industries as well.
Let's show our appreciation to Brendan